Otherwise, we'll have our conversation and then we will have to do it again.
Okay, so got it. I will
Yeah.
check, got it, live stream.
Yes, perfect.
Just a moment.
But that makes it a lot easier. Otherwise, we have the same conversation again. So thank you, Manuela, for coming
Good
in.
morning.
I'm looking forward to our conversation and hearing your experience. So I think what we can do is, why don't you just start with introducing yourself and then a bit about the background of the JAMS Fellowship and about yourself. I mean, whatever you want to tell us.
Thank you. My name is Manuela Grosu. I'm happy that you approached me with this project, and I follow your work on LinkedIn and on Facebook as well. I'm based in Hungary. So I'm a practicing lawyer. I work for KPMG as an attorney. I'm a lawyer in terms of my education and background. And why I'm also a visiting lecturer at the university, the law school where actually I graduated, and I also pursued my PhD studies. So it's interesting that currently I'm not a practicing mediator in the sense that I work as a mediator, but I am involved in a lot of things in connection with mediation, including teaching mediation and arbitration to students at the law school. I am a how to say, a big believer in mediation, and just a few weeks ago I finished the training in mediation. I participated in many trainings, of course, in mediation since back to 2010. But this time I joined a training that would entitle me to be an accredited mediator, to be on the roster of mediators in Hungary. So now it's interesting. Maybe I will also try this path. I mean to act as a mediator myself. We will see. But in terms of mediation advocacy, what the possible role of a lawyer in mediation. So these things are all the time. I'm thinking about this. I keep touch with the JAMS Fellows. I write about mediation. So the point I wish to make that it's interesting, because I try to listen to the previous mediation experience videos and conversation you had already, the JAMS Fellows and the other practitioners from all over the world, and most of them are practicing mediators. And at first I thought maybe I should tell Vikram that I am not a mediator myself, but then I thought that I'm more than interested in mediation. So I'm really in this area in Hungary, but from another point of view. But hopefully now I will enter another stage in the future. So this would be my background. I was a fellow. I was one of the first generation of the fellows. You might have noticed on the website. So it means it was 2011 when I was selected as a JAMS Weinstein fellow. It was such a privilege, and actually I was very young at that time. So maybe I was the youngest JAMS fellow ever, because I was at the moment I was only 26. But when I moved to spend 1 year in New York, by that time, and I celebrated my birthday in New York with not in New York, in San Francisco, when we had the orientation week, and that was I was 27, and I never forget this, just to have some not only professional chat. The Gabriela Asmar, I celebrated my birthday, my 27th birthday with Gabriela. I know that you had a wonderful conversation with Gabriela from Brazil, so I will never forget this, that we celebrated my birthday together. So it was many years ago.
Okay, no, but it's okay. You're still young, first of all, and the important thing is that practicing mediator or not doesn't matter. As long as you have the mediator mindset, that's all that matters. So practicing will happen. It's all happening all the time around you, so that's not an issue at all.
But we need to generate cases. It's all the time an issue. There are many mediators, not enough cases.
That is the only thing that I keep talking about, and that is what we have to do something about. And that is the target for next year. That is the target. How can we get people to be full-time mediators? That is how it has to happen, and you have to in some way participate in that whole process. And one thing that I've understood is that my lecture series, you have to give a lecture in that also. So January we'll plan something out. Yep. But then how did this whole JAMS fellowship come up? I mean, how did you get to know? And
yes, at that time I was a PhD student. As I mentioned to you, I was around 26, and very nice. One of my mentors, actually, she inspired me to deal with mediation, and it's interesting because she's not a lawyer, so she's a researcher in criminology and sociology, and a practicing mediator indeed, but rather focusing on restorative justice. So right from the beginning, my focus and my interest was on civil and commercial cases, but the idea of mediation, the idea of alternative dispute resolution, and how to integrate in the process of resolving disputes, it really was her personality and her course, even though I was not interested in criminal cases. But we decided to keep in touch. And one day she sent me an email that, Manuela, you should apply for this. And I told her that I was too young and not too junior. I mean, I'm sure that it's rather for senior professionals already practicing as judges, lawyers, professors. So I might not try it because it's ridiculous that I would like to apply for this program. But she encouraged me to do that. And also kind of an exercise, let's say, even though it's not really for me so far at this stage of my life, but it's good to learn how to put together such a material, how to express your ideas, and how to explain that you would do something abroad in connection with mediation that can bring value to your community when you return. So this was our idea behind this. And to let's do it like an exercise for me, like a PhD student. And I was writing my application, collecting the materials, recommendations, and I was very lucky because I managed to receive a recommendation from Professor Love. She's a professor, full-time professor at Cardozo Law School in New York, and she's a recognized scholar and mediator, and one of the pioneers even in the United States. It's a good thing because in the United States there are many pioneers, but she's indeed one of them. And she supported my application, and I think it was very important because my plan was that if I obtained a fellowship, then I would be also a visiting researcher at Cardozo Law School. I said, okay, I'm not a practitioner at that time. And what would be useful for me to shadow cases, to be located in one of the JAMS offices, and in the meantime, to have some academic program that I can follow, join. And the Cardozo had a cooking program for conflict resolution, very recognized program, and Professor Love is the director of this program. So my plan was, and the dream became true, that I would be a kind of visiting researcher at the university and parallel, also a JAMS fellow in the office in New York, because the law school was based in New York. So I think this was a key issue that I gained the support and recommendation from a person acting with integrity and the real ADR background. This was one. And I was honest in terms of my plans, so that maybe I won't be the person who returns to Hungary and would build mediation in 1 or 2 years. But I will write about that, and it would help me to write my PhD. So and I had a research project, and I summed up my research project, and my research had a very practical. I hoped that we have a practical implication, but and had a part rather focusing not on theoretical but practical issues. I mean, have an interview research. It's not really acceptable in legal environment and in legal research, but I managed to do it and to recognize it as a tool, as a valid tool for gathering information. Frankly, it was not an easy part. And what does it mean to have empirical research? It means that I had interviews with JAMS neutrals, arbitrators, mediators. Also, I managed to have it clients. I mean, clients usually legal counsels who appear in mediation as clients. It's interesting, the sophisticated clients, very, very special type of client, the legal counsel. And also legal representatives, very interesting issue. And I learned a lot from in New York about that, mediation advocacy. So lawyers representing, maybe not a good term, helping, supporting clients in mediation. And due to this special connection with JAMS New York office, I assessed a huge network of professionals to conduct my research. And they were really open, very active, sometimes very giving me feedbacks and very useful feedbacks. Not only, oh, it's very nice, it's very great. And I'm really thankful for that. I received very meaningful feedbacks on my research, on my questionnaire, whatever, and how to build my long-term and short-term mediation and ADR life as a lawyer. So this was my, and the research project, to conclude, I think the research project, there was a very particular one, not general mediation in Hungary, very particular research project. And the very important and valuable support of Professor Love, I think, was the two key moments in this. And being young, of course, it had this advantage, I think, for the JAMS, that returning, maybe I will not change the world, but long term, that I have enough kind of time to build step-by-step issues. So first write a PhD, write about mediation, and then get involved in professional activities. And then if I become a lawyer, then as a lawyer, as a practicing attorney, how to be an advocate of mediation, and maybe long term, how to be a mediator myself. And of course, to continue, that was a key issue from the beginning. And I'm happy that this dream became true, to teach mediation at the law school. So this is my story.
Oh, interesting story. And then what happened after that? I mean, okay, one was, of course, your research that you were doing, but otherwise, what was the experience like on a personal level? How were things there? The time that you spent?
You mean that for example, in New York? Of course, it was a great experience to be in New York. I mean, it's to be relocated, you know, and to see real mediations in New York and in the JAMS office. So I was, by that time, I was reading a lot about mediation. So my theoretical background was, I would not say that huge, but being a PhD student, of course, you know, this was my input. So I had a theoretical background even in 2011. But to gain this practical insight through the shadowing, because I was shadowing many cases, not only commercial civil cases, but also labor disputes, you know, kind of this type of disputes also, but mostly commercial and civil cases. It was extremely useful to shadow not only the mediators, but also how the advocates are acting. So this was one issue. The people were really, really open. So I had a mentor, a wonderful mentor there. And on weekly basis, we had a discussion. So what my experience, where I need more help, if I would like to shadow more cases. She introduced me to other professionals acting as mediators, arbitrators. She provided me with many materials. I think it was also a great opportunity going to real experience as a JAMS fellow, that I was allowed and entitled to join some trainings. So it was for JAMS neutrals, of course, not for me, especially as a young professional, but for these very recognized mediators, arbitrators, and I learned a lot from this. So I joined workshops that was rather for internal trainings, and it was really useful. And of course, they inform me about other events, always related to ADR. You know, it helps a lot. You say, of course, they recommended and they draw my attention. It means a lot. when you would like to gain experience and information, even just sending an article or sending a flyer of an event, I would not say to change your life. Maybe it's too a cliche to say, but definitely helps you to get involved. Because when I went to New York, I was alone. I mean, literally, practically. And you know, maybe your question was going down also to these issues. Again, not only professional but personal support. You know, what can I do in New York? How can I spend my time? I think it was very supportive, and just from, how to say, from up from the senior just to the junior level. The case management team. I think it's also a key issue. If you have an insight how the case management is working at an ADR institution. JAMS is a recognized ADR institution, very well known all over the world in resolving, including very high profile cases, commercial cases also. And it's not only about the actual mediation arbitration session, but to see the background work, let's say, how such an institution on daily basis operates, including the case management team, and how an experienced case manager is working together with a neutral assigned to him. It was also very useful to see how a precise system is it actually.
Now, that's an important part of the whole process. But let me first come to that aspect that you said it won't change your life going to a workshop or something. Now, I have a lecture series which started off with, because Ken Cloak in there's a show that I do, which is called Evolution of a Mediator. So in that, he made a statement, and that statement will tell you that it can change lives. And I will show you that statement I read it. This is what he said. Okay. So it can change your life. Even in that, in 2 minutes, things can change. So
at the moment, you have this aha moment, and actually I mentioned to you this scholar in sociology and criminology, a Hungarian scholar. She proposed me to apply for the JAMS fellowship, and that I was interested. This was the moment that changed my life. I was almost graduating from law school. So I was at the end of my legal studies. And to join this course, of course, I agree with you that you have these moments in life. Then the question is always if you can build some meaning and give some input to this moment. And it's not easy when you are a pioneer in issues, when you open or enter a new field. It's difficult, but the key, I think, that you always need to think back and you rely on the original idea when you started it. So I said, oh, it's 10 years, and I had difficulties, and I had, of course, great moments and difficult moments. I said, oh, I would never get involved in media. I would not even finish my PhD. Life is difficult. Nobody cares about mediation. But of course, there are some moments like that. We are not even talking about that. And then you get involved in mediation. I think sometimes you get disappointed. Doesn't matter if you're acting as a mediator, write about it, you believe in it, you would like to propose to your clients any ADR solution. Sometimes you get disappointed. That is difficult.
Yeah. But what has happened, Manuela, what has happened is your mic has moved its position. Your mic was in perfect position. Right now it's moved. So your sound has become a
then
little
I moved back. But then I moved back. I was just telling you that I moved back. And I'm very optimistic, but I learned. And of course, it's again something that's not new for you as indeed an experienced practitioner, that you need to get again optimistic again and again and act. You need to act. You need to, and you also need to appreciate that sometimes you can't make a huge impact, right, on everything, but little steps. So you go to a conference, you make a speech, you write something, you manage to propose it to a client. Maybe only from 10 once it will be successful. But anytime you still need to appreciate one success, that once it was working. So I think this is how it works, that you need to appreciate the little steps, not only the great success.
Yeah, exactly. Step by step, things happen. But what I was saying was that your mic, I think you need to put your mic closer to your mouth. I think that mic had moved away somewhere.
Yes, just a bit, because wait, maybe this way is better. What do you think?
It was a little better. So that's okay.
Sorry. Yes.
But what was the situation? I mean, okay.
Problem.
But is there any particular case that you were shadowing, which was really something which you would want to talk about, something interesting, something?
I'm happy to talk about. Thank you for the question. Not a particular case, but a particular method, I would say, that appeared in some of the cases, and it was very interesting to see, is the issue of private session. There is a long debate about, in theory, a long debate, maybe practitioners already settled this debate, a long debate about joint session, only joint session mediation, and whether it's good to have a private session all the time, only when parties face deadlocks, face impact, or I should use it routinely. And it was very interesting to see how efficiently and effectively and how often mutuals use private sessions and to do this shuttle diplomacy. And seemingly it's just going back and forth with the numbers, but it is not. You need to be, and this was my shadowing experience, you need to be extremely prepared as a mediator and experienced to gather the information and to know how to reframe it and deliver it to the other party. And it was shocking for me to see how difficult it is. Even though if you are on a first basis, on a superficial point, oh, it's easy. I mean, it's just saying numbers and maybe a little bit phrasing it in a more polite, a more indirect way, but I realized that it's much more. And I was also thinking, and this also goes back to my shadowing experience, that it's not only about of course, it's about how good is the mediator, because the mediator is responsible for the process, but the parties are responsible for the outcome. And just going to the parties, you need to have very experienced parties, sometimes even sophisticated, not only experienced, to be able to use the private session in a correct way. This was interesting for me because sometimes you read about that and say that you should keep the parties together, right? Because the parties will reach a settlement only if they are together, because they need to find a mutual solution. I think it is true. This experience with shadowing private sessions didn't challenge this idea, but was a clear demonstration how effective private session can be. This was one, and the second experience, again, going back to the big question, evaluative contra facilitative mediation. And in commercial cases, I think in family law is very different, and I don't have so much experience in terms of shadowing, and neither as a practicing lawyer in family law matters. So that's why I would not say. I would assume that, of course, it's very different, right? Even transformative mediation can work. But in commercial cases, there is a moment when the parties request you to give some evaluation. I would not say that directly, but sometimes, what do you think? How you see? Whether I'm reasonable, whether I'm not. And it's very interesting how different mediators approach this issue. And if you are appointed as a mediator because of your professional background, because you were sitting at the bench for 20 years or was a head of litigation at a big law firm before becoming a mediator, then it's not surprising that parties would expect you to tell something about your opinion, but your professional opinion. And it was very interesting to see how different mediators navigated through this issue. So, because as a mediator, you are not there to give an opinion, right? These are the parties should find the solution. On the other hand, they expect you to help them. So, if I would like to be very cynical, I would say they are not only paying for you to be nice. So, and how to find the balance? It's very difficult. And I was amazed to see how these JAMS mediators were able to find a balance and resolve these very tricky situations.
No, it is, I think. And I think for different parts of the world, when they see that, if some places it's not evaluative at all. So when they see that evaluative aspect, it's different for them, but definitely. But tell me something. You've seen the arbitrations also, you saw mediations also. So what is your mindset? Is it a mediator mindset or is it an arbitrator mindset? What is it?
I hope that I have both mindsets.
No, Veer, I don't
no,
know. I don't want both. I don't want both.
you don't have both mindsets. I am very disappointed, Vikram, that you are telling that, because my PhD was about combining mediation and arbitration. Oh, you are very skeptical. I am very disappointed. Combining mediation and arbitration in resolving commercial cases. And I was thinking about, even at the time in New York, and sometimes even today I'm thinking about this issue. I can't settle this issue. That if you can wear both hats, right, in the same dispute among the same parties, not in general. Even in general, it can be a question, because some people argue that you can be a mediator, can be a practicing attorney, can be an arbitrator at the same time. You need to just find one professional, let's say one way of practicing law or practicing any type of profession, because to be a mediator, it doesn't mean that you need to be a lawyer, definitely. It's not a matter of having legal education. I hope that I hope that I can change my mindset. I think it's important to be able to change the mindset. This is how I think. The reason why I'm saying, because only few people can afford, both from a professional and financial point of view, to make a living only from mediation, to be a full-time mediator. That means that you have other professional tasks in your life, not only being a mediator. At least, let's say, but I was learning from experienced mediators, this is how they started. Even at the beginning, they had another profession. And you need to be able to separate these roles in your life. And you need to be able to be independent and impartial in the mediation. That doesn't matter if you're a lawyer, or if you're a social worker background, if you're a woman, if you're a man. It doesn't matter. It means that you need to be, it's a key issue, to be independent and impartial. And it's very difficult. It's present in legal provisions, it is in professional code of conduct, but this is difficult. And if you have this key feature and ability to separate yourself in this sense, to have the parties without getting involved, without being, I would like to resolve the problems. No, they should resolve the problems, and you should assist them in this. If you have this ability, then it's very good, and of course the professional trainings would help you. If you don't have, then you will have a very hard time. It doesn't matter how many trainings you are going to join, how smart you are as a lawyer, how smart you are as a high school teacher. I remember, just to say, different backgrounds as mediators, you will have a very hard time. And maybe I'm a little pessimistic. It's a question whether you will be able to become a mediator in real life setting. On the other hand, I feel it is something, and I'm also interested in what you think about that it is also something that you can practice. So practice in terms of that, of course, first you have simulations, you have case studies, you shadow, then you act, right? First, as a co-mediation, this is the the stage where I'm currently, that I would like to resolve my accreditation and then request mediators who have cases, who have practice, who act with integrity, and to request them if they allow me to co-mediate with them. Just first, not alone, no, just co-mediate first. And to see myself, how I act. And, time will show. And so this is a moment that I would say that, of course, you have you have the mindset, I agree with you. It's something that on a certain level you can learn and you can practice, it's true. But on the other, there is a part that you cannot really. So you really need to know yourself and you have your evaluation about your skills, your communication and life skills as well. And these two things can decide if you can act as a mediator in real life. But I believe that you can change the mindset, but only with these two preconditions. Otherwise, no, yes, otherwise you can't. Otherwise, just you jungle through and make, I think you make, how to say, not help the parties, but rather make the life more difficult.
No, but I'm quite clear in this aspect that the two mindset work totally differently, and you can do everything. Everyone can do that, but it doesn't come naturally to you. You're not comfortable in it. It's not, you don't like it, because when you can see in front of you that parties can sit together and settle something, to be even take one step further and tell them, okay, let's just go into arbitration and I'll be the arbiter, or whoever else. I'm not even saying mediator should not be an arbitrator for it. That by itself is a issue there. But I'm just saying that just to take that step even further, I have been a lawyer in an arbitration and still reached out to the other party that you should settle. I mean, you can see in front of you that they can settle. Why would you take them through the process? So I have a problem with that aspect of it. That to be an arbitrator is a totally different mindset in the way
It's
you
true.
want to conduct the process and everything. And when you have the mediator mindset, you can be in any role, even in an arbitration, you can be in any role, but you would still want the parties to settle and you would find some way to get them together. So when you're doing that, that and being in an arbitration, there are so many different, it's a totally different approach. So when you are trying to see, oh no, maybe they can get together, maybe they can, I can reach out. You're always thinking that then you're not really doing the pure role that maybe what you need to do in an arbitration. So I have and that's my personal thing totally. And the other aspect of it on what you said, look, if you have the natural ability, you actually don't need to be trained or you don't need to actually even shadow. I'm telling you, I feel that because what happens is that there is a natural ability means you have your own personal style. And that personal style is what is important. And by your saying that, okay, I will become like someone else, you're actually maybe moving away from something which was so beautiful itself. To move away from that, I sometimes feel that maybe people, because something that comes naturally to some of people, they don't even realize what they did. They can actually help parties settle and they don't even know what happened. And they think, oh, is this what it's all about? No, no, there must be something more to it. No, there is nothing more to it. It's such a natural process, comfortable process. It just happens. It's been made into a very formal structure. Everything that's a different thing. It's the way it's gone about. But that's a very small part. Institutional mediation is such a small part of mediation in this world. But that's the only thing which is actually highlighted and spoken about. If you see the numbers, there's nothing there. I mean, nothing. I mean, even when you look at jams, total number of matters in the year is 18,000. This today, I was listening to the CEO's interview. He said 50-50. It's about 50-50. So 9,000 mediations in the entire year in terms of numbers say even in the US with 100 million cases is nothing. So I think institutional mediation gets highlighted, but that's not where the numbers are. Numbers are happening somewhere else. But of course, the concern that people are not being able to practice as full-time mediators, that aspect of it for them to do other things, I also find that quite sad because I hear of mediators in the court system who definitely have to practice as lawyers and litigating lawyers while their mindset is not that. The mindset is a mediator mindset. They're actually frustrated. They're frustrated. They want to get out of it. But because the profession hasn't developed the way it should have, and for that also we have to get into the reasons. You being an academician, you should get into that aspect. That what are the reasons for that? When you say on one end it really works, it's a damn good thing. Why don't people use it? And on the other end, mediators cannot practice as full-time mediators. There is some fundamental issue, and you please have to do research on that.
Yeah, maybe next stage, next research topic. But we are talking about using the term mindset, and it really goes down not only to the mindset of the mediator, but mindset of the community you are acting in. So it that's why I believe really in training, but at the law school, I agree with you. But if you don't have the personality to be a good mediator, then there is no training that would make you a wonderful mediator. There is no university degree. I agree with you. But when I use the term now in new sense, the training, educating students, what I would say here, not all of them will be a mediator, right? So if you have an elective course at the law school, not a law school, let's say business school, whatever, of course, I don't believe that they will act as mediators, all of them. But the issue here is, I think, and what would be the key takeaway for them from the course on mediation? And I was using already this communication and personal life skills. And just to have the idea, not at the age of 30, 40, 50, but at the age of 20 already, how to resolve a dispute. Because maybe you will act in an organization. Maybe you will be a part of the management level, but maybe you never, it's not a problem. Maybe you will be a team member. Maybe you will be a mentor type of person, or you will be a freelancer. It also happens, but then you have contractors and you have partners. Maybe you will be a lawyer, but you act with clients on daily basis and with your other colleagues from the law firm, and you have complex problems and you have conflicts. And of course, from some of these conflicts, and as a lawyer, I always go back to this, some of these conflicts are legal issues, has a legal impact. But at the end of the day, first, they are a conflict problem. And to have an ability to resolve problems and to understand as soon as possible what it means to focus on interest, not on position. Very simple sentence. I think it takes me many years to understand really what does it mean to focus on interest, not on position. Then I think this is the added value of such a course. Then this is one. Then, and you are telling me this contradiction situation that on how wonderful is mediation, how many people would like to practice, and on the other hand, many mediators are waiting for the first case to be appointed, frankly. So even in Hungary, there are many mediators on the roster, but most of them are not actually practicing. They don't even have one case per year. So the other thing what I see is to how you can build trust in the mediation as a profession and recognize mediation as a profession and recognize mediation as a dispute resolution tool. Let's say there are commercial civil cases which can be resolved not only in court litigation, not only arbitration, but also mediation. So how to give prestige for mediation, I think one to demonstrate the success. So it's always if something very complex, something very even involving people who are celebrities. Sounds very stupid, but really have a film, have a movie which the main role is taken by the mediator. Very, I mean, it sounds for me okay. Why should PhD saying this very ridiculous things? I have a movie, but demonstrating what's mediation and how it operates and how it can help even you. And I think this would be the second one. The third one, and just going back to my position as a lawyer, of course, you need to know a lot about mediation to be a confident advisor on mediation. So let's say this is the moment when I would propose to the client to think about mediation, to think about alternative dispute resolution, not only mediation, there are other types of alternative dispute resolution methods, but you would like your client to be empowered, to have enough information to make the decision, find that the client should make the decision if this is the path that she would like to take. In order to get there, the community of lawyers, attorneys needs to be prepared and needs to recognize mediation, acknowledge mediation as a dispute resolution method. It is also a key issue, how to make other professionals, judges, lawyers, legal counsels interested in mediation. There are financial incentives. Of course, there are mediation mindset that they are not mediators, but they have this mindset. It's easier. But sometimes you don't have this. So then you have financial incentives that can be you punish if they don't elect mediation, or you award if they yes. I mean, even based on legislative provisions, you can do that. So if you go mediation, then you will get reimbursed your duties, part of it. Let's say like that. So, or if you don't keep your immediate settlement agreement, then you will pay for the court fees if you bring the case to litigation, contrary to the fact that it's a mediated case. So demonstration of success, let's say, training people about the mediation idea and mindset, not training going to the accredited mediation training, but the same to the young level, even in high school, primary school. Very interesting. You're at the very early stage of our life to learn about these skills and a method how to approach solving problems, and to build trust in the community where you are operating, that this is indeed a profession. So it's not just nice people talking and, oh, but you think, but I think, you should talk, no, now I should talk, win-win, oh, how naive people. What does it mean? Because win-win has, of course, different meaning in different settings. It's different in family no matters. It's different when you would like to resolve an authority, how to exercise custody authority or of a kid. It's very different when you would like to arrange a commercial dispute. But what does it mean to have a win-win solution? This is how I see it. And then the fourth one, very key, and it's not only about the mediator, it's about can be on a society level, on a human being level, let's say. You need to take responsibility for your decision. You also mentioned that the parties, you assist the parties and something wonderful is happening, and the parties see that they are getting closer, and it doesn't matter how your style goes. You use a toolbox. It was evaluative, facilitative, transformative. This is your personality and your mediator skills that you bring in the room and have the party. Yes, but on the other hand, the parties also need to cooperate. And it means that they should take responsibility for the decision. And it's very difficult. And there are many research on that in different parts of the world. People take responsibility for decision easier. People sometimes like that the state take care of them, and the state take care of me if I go to the court. So I can't blame the judge. I can't blame the arbitrator that the case was not playing out well. They are not able to interpret the legal provision. They're not as smart as I am. And well, this is how it goes. But if I sign a mediated settlement agreement, even on behalf of a company, this is me who takes responsibility on a practical level. This is me who acknowledge that this is the reasonable things to do, and it's difficult to make this point. This means that you're very adult and very self-confident people.
That's really interesting, Manuela. That's what you put across is really important. All these points, of course, are recorded. We'll put, I think, being someone who's into the theory part of it and everything, please put this down somewhere. These are very important points. But I'll just take one by one. I'll take on the movie part of it. I think is very interesting because what I believe, and if you really look at it, the movies have actually pushed alcohol in the world. They have told people that alcohol happens, drinking happens everywhere. Someone walks into a house, throw a beer at them. People are sitting in a law office and pouring whiskey. I haven't seen that happening in any law office as such, but everyone has that. Everywhere there is just alcohol. Amount of money these alcohol companies, it's a huge business. I mean, the alcohol companies together will be larger than most countries. The amount of revenue they get is higher than the GDP in most countries. They must be in the top 10 maybe in terms of GDP. I don't know. We'll have to see that. But they've been able to create that lifestyle around alcohol. So definitely, if slowly mediation and the fact of collaborative dispute resolution is pushed through movies, definitely be damn good. But the only thing is that the court system and people arguing in courts makes better show of things, and people sitting down on a table and settling things might not be such a good thing.
Even reach compromise solution. Oh, poor people.
Exactly.
They are not able to fight. And especially you have this adversarial, you have the jury. Here in Hungary, as a civil country, we don't have the jury, but when you see common law country style movies, and they have the jury, and you convince them, and they go to other room, and the other room, and they are separated, and they are educated, and you have this amazing, like a theater show, how you have the process of submitting evidence and asking and cross-examination. Of course, cross-examination is more interesting, cross-examination witnesses, than okay, I think you are right. So, but that's why it's very difficult, how you demonstrate that this is something that's good, and reaching compromise and reaching a consensus-based solution is not the same. You're not always, of course, you need, you give up something, right? But you give up something for something greater, something better.
Yeah,
so,
but it doesn't make a good movie. It doesn't make a good movie because it doesn't have what in here we say it doesn't have the masala. You know what masala is? The spices. It doesn't have enough masala in that. But in terms of the other point that you made in terms of training, let me tell you, all the training that I understand ultimately leads to, in some way, conflict management and how you should be collaborative when you are working together. So according to me, that's a totally different kind of training. Damn good. You must give that. Very nice. But here I'm talking about mediators and actually practicing as mediators. That kind of training for me is not required. I've been using earlier, I was totally saying that. Now I've been saying, okay, skill development, maybe. Training means you're starting from kind of scratch. No, these people don't need that. And of course, with Gabriela, I don't know whether you heard that conversation, that there is so much more which goes into it. The energy, the spirituality, everything else. There is so much more which can never. Okay, definitely. Training is totally out. Even skill development maybe doesn't happen. This is a very, very basic part of people. So I think maybe that has got lost. So because of that, you have large numbers of mediators coming out because their training is simple. It's about conflict management, maybe. And just the fact that, okay, can you collaborate? But the actual number of mediators maybe they're not so large. Maybe they cannot be so large. Maybe the kind of people that I'm talking about, we don't find too many, because when I tell people to go visit some villages and find out, are there some people who are trusted by the people, you don't get too many names. You don't get too many names, in the sense that if you think that there will be lots of such people out there in those villages. So I'm starting from there. For me, that is the base, that, okay, let's start from there. People who are trusted there, let's take them into the profession. So that's what I'm trying to do. And I'm seeing that maybe we don't need that such large numbers, because these people can actually help people settle cases in large numbers themselves, maybe. So we don't need large number of mediators, maybe. Let's see how many come out. I mean, that whole exercise, I've started that exercise. Let's see what happens all over the world. That is the attempt now, that people can actually start from village level, wherever villages still exist. Of course, they exist everywhere, I'm sure. But that becomes one area that I feel that even in peer mediation, there is a whole discussion on peer mediation, but that training also ultimately goes down to this: conflict management, non-violent communication, those areas. Those are nice things. Be good human beings, very nice. But that's a different concept of training. Here, actually helping parties resolve a dispute, that's a different kind of a skill. It's a skill by itself. It's not something as simple as putting someone, telling them what a dispute is and how people should collaborate. Okay, teamwork and everything, damn good, must be done, but it's not something which for me is something that a mediator mindset person even needs, already has all that. So maybe that's a little difference which I have, in terms of, maybe that is why a lot of work is not happening, because large number of people have been churned out of these factories. But actually, maybe are they the ones that we need out there? That's a question. So I don't know what thoughts on that are.
Yeah, I think interesting you mentioned this. I understand the example, but you with the village, example, because this goes down to the root of dispute resolution. There was first this type of dispute resolution, then only court system and whatever formalized dispute resolution come out. And you need, if you have these trusted advisors of the community, and you have the old wise people. This is how sometimes you hear about that, and maybe this goes down to this, and this is what I was hearing from you, that there might be a lot of mediators, but only few mediators are really good, right? So I mean, I was putting it very simple.
I won't say good, yeah. I won't say only have the
capable of,
mediator mindset. Have the mediator mindset. Let's
yeah,
put it on that.
whether in fact you have the mediator's mindset, but maybe this part of the mediator's mindset, but just because of your example of the little communities, the village community, I agree with you that there are villages everywhere, that there are trusted people on the community, and you would like he or she to help you in resolving a dispute because you trust him as a person, right? Because you think that she is somebody who is fair, who would be able to be impartial, and who would understand. And it's also very interesting. You should understand my background, who I am, and where I am coming from. And sometimes maybe exactly you learn this conflict management, and you learn is a non-violent communication and these things. But in order, the people to go and put your dispute into your hands on a certain level, of course, because they are the ones you need to settle. They will sign the settlement agreement, and you are not a decision maker similar to an arbitrator and the judge. But still, they involve you, a people who they don't even know, involve you in their dispute resolution, and open up their mind. And there might be sensitive issues, there might be emotional issues, even in commercial cases there can be, and there many times there are some emotion factors, not only just about business and amounts and liability. So And yes, you are correct that to be kind of a trusted advisor, not advice because you don't advise, but to be a trusted individual, it means that it's more. It's more than just being trained, and to have this mediator mindset. That I agree with you. That I think one part of it is something that you can learn and practice. This is part, but the other part is something that you cannot. It's just if it comes from you or from your personality or not. So.
Because from the village example, why I'm saying the village aspect of it, because these people have actually demonstrated these things. They've demonstrated that is why they are trusted. It is because they are impartial. That is why they are trusted. They have the wisdom. That's why they're trusted. And this whole game that people of words, game of words that advise, no, they're suggesting based on their wisdom and the experience and every circumstances and your circumstances, everything they've taken a lot into consideration, and then they suggest. Now, what is the only issue? The symposium that I did, I don't know whether you heard about the symposium, and I will keep talking about the symposium that I did in August and September. Almost 100 speakers from more than 40 countries, and the topic was mediation in our culture and traditions. The whole idea behind the symposium was that people are familiar with the process. The word is alien to them, maybe. It doesn't matter. We don't need words. Whether you call it mediation or you call it Manuela process, how does it matter to us? As long as you are working together to resolve your disputes within yourselves, I am happy, you're happy, everyone's happy. So that part of it came, a lot of interesting things came out of that, and how traditional methods on one end obviously exist and existed. But you will hear me saying this now a number of times. I'll say it again. Colonization has been the biggest issue in the world to destroy traditional methods and create this court structure, which has been so conditioned in people's mind today that they think that is where dispute resolution happens. And you did talk about the aspect of sometimes mandatory mediation, costs on mediation, everything. And I've been saying, just judiciary, please stay away from mediation. If you can't handle your litigation, and in our case, in the country like India, even arbitration has been finished because of the judiciary, because there are matters which I won mediation. I keep giving this example of, it was a matter which went for arbitration and then to the courts. Entire up till now, 14 years had been spent. It's an arbitration route. 14 years had already been spent. We did not know whether it would take maybe another 10 years because it was in the high court. From high court, it goes to the Supreme Court. Can you imagine? Even arbitration, the courts have finished off. Now, what is the other dispute resolution system out there? Oh, mediation. Come, let us get that into our fold also and destroy that profession also. Give it for free, because obviously you want your backlog to go. So you can't ask people to pay for it. So give it for free. Don't let people practice as mediators, as a full-time mediators or as a profession. Make them think that they are doing some great thing for society by being mediators. And actually, in the court system, I mean, I've been talking about this also. In the court system, you want to give mediation for almost free, then give litigation also for free. Let the lawyers also not charge anything more. Not a problem. One day, every day, that whole day mediation concept will finish in the country. There will be no mediation centers in courts. The lawyers will make sure. Give them the same. Why are you differentiating? Why are you discriminating against mediators? Are they such special people that they don't have to run houses? Are they living on air? That's it, eating air, drinking air. It's not happening. So please understand, the judiciary is strong because of the whole colonization. Again, I say colonization. Judiciary is being kept on that pedestal. In countries are like that, I don't know about Hungary. In countries are like, the judges are still sitting on a pedestal. They are still being called your lordship. Come down, come down. It's happened. We've gone through the colonization. Today we so-called democracies. That also, of course, you'll hear some discussions I have that we don't really have democracies. We call them democracies. But there are a lot of things that there need to be mindset on. That also has to be changed. On one end, we have to find people with the mediator mindset. But this whole concept of the colonization mindset, the colonized mindset, the colonizer mindset, we have to work on that at the same time to actually get somewhere in collaborative dispute resolution. Collaborative, I don't even want to call it mediation, but people start, because on the traditional method, the fact of social pressure being there. Because of social pressure, when a person, an elderly person, suggests that this is a solution, you don't have to accept it. but because of the social pressure, you want to be part of
Exactly.
community.
This is what I was actually trying to refer to, that they are known by the community, they are respected, they are the old white men who know how the things are, and they know you, and you would feel ashamed if you don't accept the solution, because you know the truth is something, it's very difficult to attend once, that you would like peace. So in the community, you would like rather peace, and sometimes you need to give up, and
Exactly.
the peace is more important than am I right? Am
Exactly.
I was right?
Yep.
And to be able to give this up, and as you have mentioned, yes, you would like that your community accepts you, and you don't want to feel that you were doing something that disrupted the social harmony in the community, that you are the one who
But
who started this process. You would like to resolve it, and exactly because you have these um, trusted individuals in the community, then the reason why you accept, but he or she is proposing one is because of you would like to be socially accepted by the others, because this is a small community, and the one because indeed you trust that he or she is right. So I understand the things, and would propose something fair.
yeah, and the main thing I tell you,
Um,
Manuel, yeah, Manuel, the main thing what I keep saying is that is it so wrong to want to be part of a community and having social pressure? How is it really wrong? But I think concept is coming from societies which are individualistic
no, I don't
societies.
think that it's wrong. The concept indeed comes from there, and this concept is older than the judicial system. What I say, that there are cases and situations and human interaction that 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 can be resolved like that. But I would say that the people, especially nowadays, are not as connected anymore, right? And and we still would like to keep mediation going. We do, yes, in a kind of formal way, and we learn how to say the opening statement, and we learn how to say that what's confidential and not, and how a mediated settlement agreement can be executed, and you learn by heart what's my role as mediator, to be able to tell the parties, and it maybe it's very disappointing on the one hand, but on the other hand, um, there are settings, environments that you have no other chance to do just like that. I understand your point about court and act mediation, but I was hearing from you that you don't really believe that court and act mediation is something that needs to be institutionalized, that is useful. But experience, and I learned from judges, not only in Hungary, but from other countries who helped establishing such court annex programs. Maybe they themselves are not acting as mediators, but develop the program at the court where they serve as judges. Is that when mediation is not as recognized in this kind of new wave of mediation, then the court and act program is the place where you can sort of demonstrate to the parties that there is mediation. When there is a pending court case, or when the court case is initiated, the statement, the claim is delivered, then this is the moment when you can draw the attention of the parties that there is something that mediation, and then a court mediator can help you. I agree what you were telling, that it's free. If it's good that it's free, of course it's not free because they are paid by the state, but from a client perspective, party perspective, you're right, this is something that's free. And sometimes the court clerks are responsible for handling such mediations. And what the effect of this institution to private out of court mediation, right? Because if something is free and integrated the court system, and the judge knows my attention to this, then maybe I would choose that one. Maybe court and mediation is something that's temporarily needed. Of course, this idea can be challenged. There are
But
two facts.
yeah,
Temporarily needed. It means that not for
I,
20 years,
no,
but for
I'll
a few
tell you,
years.
Manuel,
Yeah.
I'll tell you, I'll give you the example of the US because obviously you've also studied there and you've seen the situation. 100 million cases, 40, 45 years of mediation in the court system. So it's not a temporary thing. 40, 45 years is not a small
Yeah,
thing.
they still have the court next
Yeah,
the
no,
court
I
next
know. I'm
mediation.
saying at
Yes.
the end of that, what has happened is that the matters are going into courts. out of all these years, what is our purpose of trying to tell people to use mediation is because you want that culture to go out. You want people to understand the benefits of mediation
Yeah.
so they can go for mediation directly. Like you also said, mediators don't have to be just lawyers or any, they don't have to be connected obviously to the court system. The people have to come out as mediators from various parts of communities and different professions and everything to be doing it. In 40-45 years, that doesn't seem to have happened. So to say that that model works, we know it doesn't work. At the end of the day, what has happened, let me tell you, Manuel, how I see it, because I've also tried to dig a little deeper through this symposium and everything, was that people are taken to courts by the lawyers. So everyone goes to lawyers. Now these matters go into courts. There are mediation centers there. There are mediators who come into, they enroll themselves in that center, thinking that today we are going to be practicing there. Some lawyers will recognize us and then give us private work. Doesn't happen. They get disillusioned, they move out. Another lot comes in because obviously they are being trained, so they think that okay, let's get some work. They get disillusioned, move out. So at the end of the day, private practice doesn't develop. The lawyers make their
Yeah,
money.
that's
Lawyers make their money. They are very happy with the whole process. They have very nice structure. The mediator doesn't have to be paid, so there is more for them to get paid, and it becomes a lawyer to lawyer deal making situation. The mediation as, and there's nothing wrong with that. If that's what the is required, deal making is required, not a problem. That they should be able to do that. That part of it, I have no problem with that. It doesn't mean that we have to have one kind of mediation. No, if that's required, that's required. But at the end of the day, what is my concern? My concern is mediators should get work. That's what we want. They should get paid properly. If they are, if it's called want to be a profession, if you want it to be a profession, if you just want them to do this as good work because they're good human beings. I was telling, I don't know whether did you meet Hiro Aragaki in Jams? Okay, he was also in Jams, and I had that in conversation with the beautiful mind, and I told him that this evolution of a mediator series I'm doing, and the idea is to get some common thread between these mediators who are senior mediators, and one common thread for me was that they're all good human beings. So Hero tells me, I don't think I'm a good human being. I said, no, you are. You are a good human being. So we are expected to be just good human beings out there and just do good for society. We have to change that aspect, and the court system hasn't helped. It hasn't helped develop the profession, because profession develops when people value the profession. People do not value the profession. They ultimately have valued the lawyers who are getting them the deals. They value them. So that process keeps going on, and nothing will change by us saying that no, no, well, like you said, 10 years, 20 years, let it go on. No, the judiciary, it's their self-interest. But at the end of the day, the number of matters which go into courts, we have to stop those, because if the judiciary has to clear its backlog, less matters have to come in. But the matters, if I've been giving people this example that for a population of 300 million in the US, 100 million cases go filed in courts. In India today, only 18 million are filed in a population of 1.3 billion people. So definitely there's something happened on the background. There was one report that came out from one of our think tanks in India, that only maybe 3%, they have a variation. They say maybe from 3% to 25%. Only that many matters go into courts. Everything else is being resolved outside. So what are we trying to do? Create a situation that finally we also become the US and we have 400 million matters going to courts. We can't handle 18 million. 400 million is out of the question. So I think that there is some model which keeps going around the world. Someone creates that model from certain whatever their own understanding, because they're looking at it from a different perspective. But finally, what do we want? We want people to settle the matters within themselves as early as possible, and to value mediators at the first instance itself. And of course, they have to be trusted. It's not that they should be just getting mediators involved and not trust them. Of course, the trust has to be created in society. And over years, why I was saying that grassroots level, because these are people who already exist. But of course, there will be people who will come out from communities and business communities. There is one business community in India which handles matters only within themselves. They mediate within themselves. No matter from that community goes out into the courts. So because they find the people within themselves whom they can trust within the business community. So that is also a community. Community is not only residential communities. There are all kinds of communities. So I think we need to create that culture as such, and find the right people to do it. Not just say, okay, Anyone who goes for a certain training now has understood and become that mediator as we need it. Those are a lot of factors. I mean, of course, a short conversation, everything not going to happen. But good thing is you have all the right thoughts together, which is what I like. This discussion definitely will be interesting as we do a longer one, because obviously you did indicate that you had shortage of time. So if you're being polite, perfectly don't be polite, because I can go on for long time.
No, I would like to say a few more comments to react. So it's a long-standing issue and debate. But the effect, of course, on like mediation, on private mediation, and how they can exist simultaneously, right? And if they exist simultaneously, then those cases that would have some chance to go on mediation would rather go on court mediation. Of course, you need to have a court environment in the sense that it's a pending case or it's a case that will be initiated. So the dispute needs to reach that stage. So I still see that there are those disputes that would not reach that stage, still something that can stay in the private mediation sector. It's not. It's definitely the private mediation sector is in a difficult situation, and especially if you would like to make a living from this as a full-time mediator, then especially that means that you belong to the private sector mediator market. It's indeed not easy. Although even as a private mediator, you can participate, I think, in most of the jurisdiction in court connect mediation, but the fees there of a mediator are substantially lower than in the private mediation sector. That is true, and I was listening to your argument that why they think that mediators doesn't make a living, right? So it's just a kind of nice people, as I mentioned, nice people helping other people, and that's it. So no, it's a profession, and you need to bring prestige to it, and to be a trust, and that's why I agree that private mediators some needs to take kind of the lead and to figure out maybe this kind of network and networking issues, as well as talking and involving other professions. So I would say that I'm not saying this only because myself I am an attorney. I really believe that it's very important to convince lawyers, practicing attorneys, representing clients in arbitration, mediation, litigation, whatever, that mediation is not something that how to say, there is not a competition between mediation and the lawyer's work. You can have your client in mediation, and the happy client returns, just to put it in a very simple way. Happy clients returns means that you will have repeated business. So if you help your client to find a solution, you are the deal maker, you mentioned deal makers. That I think you can be a very good deal maker, not only when you are, how to say, the shadow or in the shadow of the court system and you feel under pressure to settle. I understand you feel really under the pressure to settle, and you will settle, and the lawyer will help you as a deal maker. And you have this court and nice programs, and the court clerk trained as mediator would have something, and is very smart, knows the law, even knows how to do it. But as you mentioned, keep outside the court system. It's very important for the lawyers to understand. And I think it's also for the mediators to help the lawyers to understand that they can kind of partner on this. So to help the client, the mediator as the one responsible of the process, and the attorney, to help your client. And but help in a way that still allow your clients to act independently. So to take the ownership of the case. You can still give some advice on legal issues. You can still give your make kind of assessment, because at the end of the day, the client is not expecting you to resolve the dispute. The client is expecting you to help resolve a problem. The client will think, this is the legal dispute. I have the legal based on this and that legal provision. So to see the lawyer themselves as problem solvers, and to see that mediator is a partner in this. The mediator is someone who can help you in this and your client. And yes, you are right. And yeah, and you can be a deal maker. Yes, exactly, a deal maker, but in a good sense, not pushing the client in the deal making arena, but on an informed decision. And to think over what the dispute, how you know your client, you need to really know your client. It's not only about, oh, small claim, easy dispute, easy case, then it's good for mediation. It's not a serious one. Even the client is not serious, they can mediate it. No, to be able to make an assessment even for complex disputes, whether it is good for mediation or not, or to allow your client to make this decision, but you need to give enough information for your client to do it. So that's why I feel that it's a room for partnering more between the mediator and the lawyer. And I agree with you, so out of the court system way. So I really see that. Of course, it's not easy to get there. And we were talking about many opportunities that we should take. It's definitely not easy. But I'm still optimistic. I know that you talk to many judges, so maybe on the Court Connect program, they tell you many things. I had fellow mates with judge background. It's very interesting, of course, to see how a decision maker thinks about this. So it was, I learned a lot from the conversation with them. I just wanted to react to this because I see the record the next program,
No,
but
no,
I
but
see
this, yeah, but there
I
is still
see
more,
your
Yeah.
point actually,
No,
and I understand that
Manuela, you're
because
still talking about, you're still saying quotes. I am saying one day I want to wait for that day when we don't even mention the word quote. That is what the whole thing is, because I'm telling you, this is the colonization mindset that disputes only get resolved in
I
courts or
understand.
with
I mean that
lawyers, or with
we need to
lawyers.
get back the dispute into our
Exact.
hands, right? We need
Because
to get back the resolution of the dispute into our hands, and not to appoint somebody we don't
and
even
both I'm
know.
saying, and that colonization mindset is that the lawyers and courts, these are the people and the institutions required where dispute resolution has to happen. We have to finish that whole concept. Interestingly, let me tell you, there was an arbitration center which was inaugurated 2 3 days back in India, one city in India. Who are the ones there? The Chief Justice of India is the chief guest. The judges of the Supreme Court are the guest and the speakers, and they are part of the whole thing. What do they have to do with arbitration? That arbitration was created because the courts could not do their job. Otherwise, why would we need private courts to be set up? Private courts is different. They want to get into every dispute resolution system that is happening. We have to get them out of it. Judiciary does just do your job. You have a job to do. There are constitutional requirements of yours. There are cases where, of course, even the cases of the state, which people think that need to go only in litigation on the courts, those cases also, this restorative justice area, which is being, of course, today a lot of discussion is happening on it, but traditionally this is all being there. And again, I keep giving this example. People who hear the same thing must be saying, this guy just keeps repeating the same thing. But you must have a look at James Mangarere's session in the symposium on the aspect of Kenya.
I
What is
will
the
do so.
situation? Have you seen that? Did you hear
No,
that?
but I will do so. No, I haven't seen
Because
that
he's
yet.
really this.
Otherwise, I would be more prepared to your that you are an advocate against court and mediation program. I
No,
understand
no,
your point.
what I'm against the fact that you are discriminatory. You are saying that the lawyers can charge what they want, but a mediator is going to get a certain fixed nominal thing in the
I
same
agree with you. This
same
is what I
situation.
mentioned.
Yeah,
Yes,
it's the
this is
same
why I mentioned
situation.
to you
Yeah,
that if you even as a private mediator, you go to serve as a mediator in the Court Next program, then your hourly rate is definitely lower,
and
and if it is a recognized profession and you add value and you create value for the parties, and what could be greater value than resolving a dispute and helping people
exactly,
to resolve a dispute? What could be, how to say, a better feedback that is something that works?
exactly.
And then why this is not remunerated and acknowledged not only from professional but also financial and
Just
indeed moral
yeah,
perspective, these three perspectives, fairly and on a fair basis and fair level. I do hope, Vikram, that this is something that even your programs and your initiations will have to spread the word of
no,
mediation.
because I can Manuela, because the thing is, I can speak independently about it because I'm not dependent on the court system. I
Yes,
run my full as a full.
exactly.
I practice as a full-time mediator. I have enough work for myself. I'm not dependent on any
So you are the
institution to get
lucky
work.
one, right?
No, I've created that. I've created it. Everyone, there's
I
so
know, and
much
I can
work.
imagine
I'm
how
saying there is
difficult
so
was.
much work. I keep telling
I'm
people there
sure.
is so much work available. It's just that the fact that we are letting the court system devalue mediators. How will someone be able? How will you tell someone to pay fees, proper fees, if everyone says in the courts this guy gets so much? Why should we be paying them anything more than that? If they even mention such a thing, the point is, I keep telling people about the court system, the mediation centers. They're run by senior lawyers. Senior lawyer might be charging $10,000 for a hearing, and the mediator in that court, in that mediation center, which is run by that senior advocate, will get maybe $100 to $200 for the entire mediation. How is it fair? I mean, we are sitting, judiciary is supposed to look at, you are supposed to be fair in things. Discriminatory to the extent where, I mean, you are today, people look at you, that where discrimination happens, you should be coming in. And you are the one who's discriminating and getting away with it because you have a self-interest, and you are the judiciary, and the colonizer concept and the colonized mindset that judiciary is always right. Manuela, I'm a little passionate about this, and I'm sure you don't want to hear it.
No, no. I mean, yeah, you mentioned, of course, that of course, yeah, you are a practicing mediator, and you talk to many people. I still believe, and that this would be my minor closing remark, that still believe that it's not. Of course, it's also about institutions that have legislative framework and have we monopolize. I would say this word, monopolize justice. Serving justice, providing justice, whether we provide justice or only exercise
Yes,
law, we apply legal provisions of provide justice, right? These are bigger questions. I think at the end of the day, it really goes down, and let me repeat myself, to the issue that you need to take ownership of your own dispute. And if you don't, it's not a matter of court annex or not court annex problem. Saying that I understand your point really well, that it's really about be able to on a social level, community level, and agree that not only village is a community, a huge company is also a community. And if you have an efficient dispute resolution system designed inside, then it can make magic. So this is also community at the end of the day. We
exactly.
don't say community. We say, oh, this is a huge company. No, this is also a community. And from our perspective, a dispute resolution professionals and to get back the ownership of dispute resolution. So this is what I really hope that it happens step by step. And it also needs to have a so enthusiastic and prepared professionals, and you are. I am amazed that you invest many time from your own time also to help others. I think it's a great thing, and you do something not only for yourself, but it helps me to go. It helps me always. And this is not really a mediation value to always focus on what can I benefit. Always we have this mindset, what I can benefit. We have also in litigation and everywhere, what I can benefit from this, but how can I benefit greater value and scope of people. So I hope that yeah, that we will keep in touch, and I will follow your work and your channel. And thank you so much for contacting me. And I really enjoyed the discussion, and I enjoyed it because it was not only kind of we had these cliches and yes, nice, and this is nice, and how you learn the peacemaking attitude. And I really appreciate that you challenged me. I think it's very important that mediators challenge themselves and each other. This is how a profession can develop and evolve. Uh, and thank you, especially thank you for for the challenging questions and ideas. I take it with myself. So thank you very much, Vikram.
No, thank you, Manuela, for at least appreciating, because look, I have some radical views and a little too passionate about it. But when I hear of that one mediator also who is getting frustrated because they don't want to practice litigation, but they're forced to do it even for one day. I keep giving this example of Constantia in Brazil. She's a friend of Gabriela's, and she said in that symposium, in her session, I want to in my lifetime see that I can practice as a full-time mediator. Can you imagine what people are going through? So definitely, but we definitely we're going to be doing a lot of, we'll collaborate and do a lot of things together. So thank you very much for accepting my
Hope so.
invitation. It was a pleasure talking to you, and I love the fact that you understand the thought process behind what I'm saying. So
Thank you very much. Have a nice day, Vikram. I